that first file.
Yeah.
Actually, the first two.
Yeah. And this one has a judgment in it as well. You said you want the first three?
Yeah.
Okay.
And I have the.
Okay. Okay.
Okay, Miss Robinson, if you're there, I cannot see you.
Yeah, I don't know what's happening. My video was working a minute ago. Can you hear us?
I can, yep. So if you want to go forward, that's fine. We can do that.
All right.
Because we do have a good audio connection. So we're on the record in Enox versus Evans. Is that correct?
Correct.
Sorry, it didn't come through there.
Correct. Brooke Robinson appearing on behalf of the plaintiff, Holly Enox.
All right. Thank
Holly
you.
is appearing via Zoom in my conference room, seated to my left.
Okay. And this is file number 26-20303. This is the date and time set for entry of a default judgment of divorce. Were you ready to take proofs from your client?
Yes, Your Honor.
Ms. Enox, are you able to hear me okay?
Yes, Your Honor.
Can you raise your right hand and let me know once it's raised?
It is, sir.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, Your Honor.
Thank you. You can lower your hand and Ms. Robinson proceed whenever you're ready.
Thank you, Your Honor. Ms. Enox, please state your name for the record.
Holly Ryan Enix.
Are you the plaintiff in this matter?
Yes, I am.
How long have you lived in the state of Michigan?
Since 2021,
How long have you lived in this county?
2021,
When was the complaint for divorce filed?
January 2nd, 2026.
When and where were you and Mr. Evans married?
In Missouri on March 31st, 2007, Cass County, Missouri. Belton was the name of the town.
Thank you. When did you separate?
In 2009 on October 31st,
When was the last time you saw your husband?
probably a week before that. He was not there when I got my stuff out, and we ended up doing an official separation at that point.
Was the defendant properly served with your complaint via publication?
Yes, he was.
Has the defendant failed to answer or otherwise appear in this case?
Yes, he did not answer.
Were any children born or adopted during the marriage?
No,
Are you currently pregnant?
no,
Have you and defendant accumulated any marital assets or debts needing to be divided?
no,
Has there been a breakdown of the marital relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable likelihood that the marriage can be preserved?
yes,
Is everything contained in the proposed judgment true and correct to the best of your knowledge?
yes,
Are you asking the court to enter the proposed judgment of divorce today?
yes.
Your Honor, do you have any questions?
I do not. So I have reviewed the file. It does look like the defendant was properly served with the summons and complaint. It looks like there were a number of attempts made for personal service. A proper motion was filed for alternate service, which the court granted and which was complied with by the plaintiff. So the defendant was properly served. The defendant did not file an answer or otherwise defend. The defendant was given notice of the date and time of today's motion for entry of default judgment, and it has not appeared before the court today. So I find it would be appropriate to enter a default judgment of divorce. The court has heard the testimony of Ms. Enox and finds that it does comply with statute and court rule and establishes the grounds for divorce under Michigan law. I have reviewed the proposed judgment. I find that it is proper, so the court will enter that judgment with today's date. And Ms. Robinson, anything further we need to address for the record today?
No, Your Honor, thank you.
Okay, thank you. And then I know you have the next matter, so if you just want to remain here on the line, we'll start with that one as soon as we're ready.
Thank you, Your Honor.
Thank you.
Thank you.
Okay, we do have everybody connected for the next matter, which is Schlosser versus Schlosser, and this is file number 26-20424. I could have counsel both put your appearances on the record, please.
Good morning, Your Honor. Deputy McCoy on behalf of Elizabeth Schlesser, who is here in my office.
Good morning, Your Honor. Brooke Robinson appearing on behalf of Ryan Schlesser, who is appearing via Zoom.
Okay, and counsel, I did receive a copy of a proposed consent judgment. And Ms. Dutzman-Coy, did you want to proceed with entering that judgment here today?
Yes, Your Honor.
Ms. Robinson, is that how you wanted to proceed as well?
Yes, Your Honor.
Okay, Mr. and Ms. Schlesser, if the two of you could both please raise your right hands. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do.
Thank you. You can both lower your hands, and Ms. Dutzman-Coy, on behalf of plaintiff, if you wanted to proceed first, please.
All right, Liz, could you please state your name for the record?
Elizabeth Esther Schlosser.
And you are the plaintiff in this divorce proceeding?
Yes,
And you commenced this action by filing a complaint for divorce on April 23rd, 2026, is that correct?
correct.
And you were a resident of the state of Michigan for at least 180 days and Otsego County for at least 10 days before you filed that complaint.
Correct.
All right. Your spouse, the defendant, is named Ryan Schlesser, is that correct?
Schlosser, yes.
Okay, I think I've been saying it wrong.
That's okay.
And you and he were legally married on January 14th, 2022, or yeah, 2022 in Carthage, North Carolina, is that correct?
Correct.
And you were married by a person authorized to perform marriages?
Correct.
And you are asking that your last name be modified back to Turnbull, is that correct?
Correct.
And that is Turnbull.
Yes,
And you and your spouse have no minor children, is that correct?
correct.
And to the best of your knowledge, information, and belief, you are not currently pregnant, is that right?
That is correct.
Okay. Has there been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
That's correct.
Okay. Do you believe there's any chance for reconciliation?
No.
Okay. And you and your spouse came to agreements regarding all of your personal property and your debt, and both of you signed a judgment of divorce, is that correct?
Correct.
And neither you nor he are going to receive spousal support, is that correct?
Correct.
And do you understand that after today, that's forever barred? You can't come back to the court and ask for that in the future?
That's correct.
And you and your spouse have otherwise divided up everything that you have, is that correct?
Yes.
All right. Do you believe that division to be fair and equitable?
Yes.
Okay. Are you asking the court to enter the judgment of divorce that both of you have signed and presented to the court?
Yes.
Okay. I don't have further questions, Your Honor. Thank you.
Ms. Robinson, did you have any questions for Ms. Schlesser?
Not for Ms. Schlesser.
Okay, and then if you have any for your client, Mr. Schlesser, you can unmute yourself, please.
Yes, thank you. Mr. Schlesser, you are the defendant in this matter, is that correct?
That is correct.
Have you had an opportunity to review the proposed judgment of divorce?
Yes, I have.
Have you discussed it with your attorney?
Yes, I have.
Do you understand all of its terms?
I do.
Do you believe the judgment fairly resolves all issues between you and the plaintiff?
Yes, I do.
Are you asking the court to approve and enter that judgment today?
Yes, I am.
Has anyone threatened you or forced you to agree to these terms?
No,
Are you entering into this agreement freely and voluntarily?
I am.
Thank you. No further questions, Your Honor.
Ms. Dutzman-Coy, did you have any questions?
No, thank you.
All right, thank you. The court has listened to the testimony of both parties in this case. The court finds that the statutory grounds for divorce have been met by that testimony. The court will grant the divorce. I've also had an opportunity this morning to review the proposed consent judgment. The court finds that it is generally equitable and contains all the provisions required by statute. The court will sign that judgment. And I'm signing it in two places, given the signature pages were submitted separately. So the court is signing that judgment in two locations, given the separate nature of the signatures. Ms. Stutz-McCoy, anything further from your side today?
No, Your Honor, just checking that the court also received the consent order for name change. It's a separate, order, Your Honor.
I did.
Okay, that was all I wanted to check on. Thank you.
Ms. Robinson, anything further from your side?
No, Your Honor, thank you very much.
Thank you. That's all for this hearing today. All parties are free to disconnect at this time.
Thank you, Your Honor.
Thank you.
Okay, we have everybody connected, so let's go on the record in People versus William Deaver. This is file number 18-5460-FH. If I could have counsel put your appearances on, please.
Good morning, Your Honor. For the record, Mike Roll on behalf of the people.
Judge Mike Flagstead, P number 79314 on behalf of Mr. Deaver.
Thank you. We're on the record here today for a hearing on Mr. Deaver's application to have two convictions set aside from back in 2018. I did have a chance to review the application, the supporting documentation, as well as the file generally. Mr. Rolla, I did receive your filing as well. And so I guess I want to address that issue first. I did see in the file that there is a report from the state police indicating that there aren't any charges from other states, and a copy of his criminal history, which reflects these as his only convictions. And Mr. Roll, I don't know if you just didn't get a copy of that, but it looks like that was filed back in April, maybe.
Yes, Judge, for the record, our office received a copy of it at 8:35 this morning.
Okay. Did you have a chance to review that in the short time you've had it?
I did, Judge.
Okay. Do you still have the same objection that you had previously?
Actually, Judge, I do not. And in fact, the objection was actually sent as kind of a reminder to defense that if you hadn't filed this, please do so. And because our office had not received a copy of it. And while I may not have made the original plea offer that was done by my predecessor, it is what it is. And now under the statute, our office no longer has a statutory objection.
Okay, thank you. Mr. Klagstad, then, were you prepared to address the issues remaining, which are Mr. Deaver's behavior and circumstances since the conviction, and the reasons why it would be in the public interest to have it set aside?
Absolutely, Your Honor.
Okay, Mr. Deaver, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand, and Mr. Klagstad, whenever you're ready, please proceed.
Bill, since 2018, have you been charged with any crimes?
No,
Since 2018, have you had any traffic tickets?
no,
Do you have any pending tickets or charges?
no,
Are you on probation or parole for any reason?
no,
Other than these two underlying offenses that you're seeking to have the judge set aside, do you have any other felony convictions?
no.
So these offenses are kind of the one black stain, so to speak, that prevents you from being a legal firearm owner. Is that correct?
That's correct.
Bill, I understand that you're retired. Can you tell the judge how you spend your time today?
Mostly working around my house. In warm weather, I go to a lot of bike nights, which is charity.
Okay. You're talking about motorcycles, I take it?
That's correct.
Do you have your motorcycle endorsement?
Yes.
And it sounds like you're a motorcycle enthusiast.
Yes.
Okay. You mentioned these bike nights for charity. Can you tell me a little bit more about that?
Yeah. They end up with a 50-50 drawing, which participant, whoever wins it, usually wins half of the pot, and then the other half goes to charities, Toys or Tots, St. Jude's, veterans. Also includes work on houses for veterans. I haven't done any work myself, but that's where the money goes to.
So it's like a bike show, but with a charitable interest. Is
That's
that right?
correct. All of them are.
How often are you participating in that kind of thing?
About 4 times a week.
Okay. Other than these bike nights that you participate in, any other sort of charitable activity or volunteering that you can tell the judge about?
I donate to Toys or Tots personally. Also DAV for Disabled American Veterans. And whatever I see in grocery stores or whatever for vets. I donate a lot to the veterans.
Okay. My understanding is that years ago you used to be a hunter. Is that right?
That's correct.
What did you hunt?
Deer, turkey, grouse, small game.
And you've not been able to do that since these convictions. Is that correct?
That's correct.
Is there any hunting that you'd like to do?
Dream would be Kodiak Island for the big bear. That's a dream.
My understanding is that's in Canada. Is that right?
That's correct.
Okay.
Kodiak. Yeah.
Do you believe your felony convictions are a problem for traveling or entering Canada?
Yes.
Okay. Is there anything else you'd like the judge to know about either these convictions or your conduct since?
None.
Okay.
All right, thank you. Mr. Rolla, having heard Mr. Deaver's testimony, do the people take any position on whether the court should grant the relief?
No, Your Honor, thank you.
Mr. Clagstad, anything further you wanted to say in support of your client's application?
Briefly, Judge, in discussing the underlying case with Bill, he knows he was in the wrong and he accepts that. And I believe Your Honor was the sentencing judge. You probably know more about the case than I do, so I'm not gonna bother. I do think that our societal attitude towards marijuana has shifted. Nevertheless, he accepts and he understands his behavior was unlawful. He turned 74 today, Judge. As he testified, he's interested in hunting bear in Canada. He also mentioned hog hunting to me. Essentially, Judge, he's not sure how much time he has left to pursue those dreams, and he'd like to get started.
All right, thank you. First of all, the court did review the file, again, generally prior to the hearing today. I do find that Mr. Deaver has met the statutory requirements to have both of the convictions that he's applied to have set aside, leaving the only remaining issues, his behavior and circumstances since the conviction, as well as public interest. First of all, I would note that in reviewing the file and refamiliarizing myself with Mr. Deaver's case, and looking at the court's sentence that it imposed at the time, it's my view that this was not any type of assaultive type crime or any type of crime that involved a danger to public safety. The court notes that these are the only two convictions on Mr. Deaver's record, and that he has not had any further entanglements with the legal system since these were entered back in 2018. So his circumstances both before this and since have indicated that he's generally lived a law-abiding lifestyle. The court finds that engaging in activities such as hunting and travel are generally in the interests of our community and in the public interest. Those things require payment of licensing fees and so forth, which support hunting and fishing activities and support maintaining the habitats and so forth for those things. And certainly travel injects money into various communities where people travel. And that's also in the public interest to have people doing more of that as opposed to less, solely because of a conviction like we have in this case. So for all those reasons, the court finds that the statutory requirements have been met and that the conviction should be set aside. Mr. Clagstad, I do have an order that was submitted with the application, so the court will enter that with today's date, and you can get copies of that from the clerk's office. Mr. Clagstad, I also want to, I forgot to address this, but I did receive a letter from one of Mr. Deaver's neighbors that was very complimentary of him and their experiences with him as neighbors, which indicate that, again, would support the court setting aside the conviction. Mr. Clagstad, anything further that we need to address from your side?
Judge, just briefly, I don't doubt that Mr. Rolla's office did not receive a copy of the MSP response. Unfortunately, this has been getting a little more spotty, and I do appreciate him sending out notice so that we could round that up, so to speak. So I do appreciate him letting us know he didn't have a copy.
Okay. Thank you. Mr. Rolla, anything further from your side?
I just confirmed, Judge, our office also received a copy of that letter again this morning, also at 8:35. Thank you, Judge.
Okay. Thank you. That's all for today. All parties are free to disconnect at this time.
Have a nice day.
Thank you.
See you, Mike.
Okay, 11, no. 45, that's,
Yep, I still have that one on.
can I take a look at that one?
Yeah, of course. Right.
And that before.
And then on
All right, Mr. Trentadue, are you able to hear me okay?
Yes, Judge, I apologize for being late. I'm out of the country and I looked at the notice incorrectly. But I am here and ready. I just tried to call my client, Judge. I had told her 11:15 she was going to call in by phone. Judge, do we need my client available for this or not?
Is her last four digits 3943?
I believe that's it. That's probably her.
Okay. All right, do we have, let's see, we have Miss Stinson on the line.
Hello?
Are you Miss Stinson?
Yes?
Okay, great. All right, so we'll go on the record. This is a matter of surplus from a mortgage sale. This is file number 2620456. We have Mr. Trentadue here on behalf of the petitioner. We have Ms. Wright from the Otsego County Treasurer present as well by Zoom. And Mr. Trentadue, I did have a chance to review your petition. Before we get into that, Ms. Wright, did you have a chance to review that too?
Yes.
Do you take any position on this?
No, I have no opposition or anything to it. I agreed with the amount they're showing as the surplus we're holding, so.
Okay, great, thank you. Mr. Trentadue, is there anything that you wanted to state in support of that petition here today?
Just briefly that we filed this petition on or about May 26, 2026, and I do have Ms. Stinson available. Your Honor, this was originally based upon a mortgage that was created by Ms. Stinson and her ex-husband. That mortgage was subsequently foreclosed, which resulted in the surplus matter that's here before the court today. Just briefly, Judge, there were some facts that I just wanted to make sure the court was aware. Mr. Stinson and my client got divorced at some point, and the mortgage was in both of their names. The divorce judgment granted Ms. Stinson the property, and there was a conditional, it was executory, Judge, meaning that she had to pay him some money in order to complete the terms of the divorce judgment. She did wind up doing that before he passed away. Your Honor, just really more of belt and suspenders than anything else. I went ahead and made sure that their children, and this is also my client's children, signed affidavits releasing any potential interest that they would have in the surplus. Your Honor, again, we're before the court today as a result of this mortgage foreclosure. A third-party bidder purchased the mortgage at sheriff's sale. The resulting foreclosure or the resulting surplus amount, Judge, was $19,032.76. By statute, I did send notice to the sheriff and the treasurer. The treasurer appeared. I actually talked to the Otsego sheriff prior to the hearing, Judge, and I indicated the purpose of sending that notice was merely statutory. I've not received anything from the sheriff objecting to this, and as the treasurer indicated, they've taken no position, nor have I received any documents from them. What we would ask, Your Honor, is that the court grant our petition at this time, that the surplus be released, and I did provide a proposed order to the court as well.
All right, so I did have a chance to review the petition and the supporting documentation. I also had a chance to look at the statute governing this type of action. And based on the supporting documentation, I'm satisfied that the only claimant here would be Ms. Stinson. No one else has appeared to contest it. Again, as Mr. Trentadue indicated, notice was given to both the Treasurer's Office and to the Sheriff's Department. And I did see the affidavits as well. I think given all the supporting documentation establishing Ms. Stinson as the sole claimant, the lack of any objection or anyone else coming forward to contest it, and looking at the statute and the court finding that the petition is otherwise in compliance with the statute, I find that Ms. Stinson is entitled to the relief requested. So the court will sign that order. And Mr. Trentadue, I will just leave it to you to communicate with Ms. Wright at the Treasurer's Office for implementation of that order. Was there anything else that you needed to place on the record, Mr. Trinity?
No, Your Honor. Thank you for your time this morning. Like I said, Judge, I'm out of the country, so I apologize for being a little bit late.
No problem. Thank you for that. And Ms. Wright, was there anything else that you needed to state for the record?
Nope, I am all set. I'll just need a copy of the order in order to process the check on my end.
Okay, thank you. That's all for today, and all parties are free to disconnect at this time.
Thank you.
Thank you, Judge. We appreciate it. Have a great day.
Thank you.
Hello?
All right, Mr. Shimovitz, are you there?
Yes, I am.
Okay, great. All right, so we'll go on the record. This is Kent Family Farm versus Vaughn. This is file number 2419708. If I could have counsel put your appearances on, starting with Kent Family Farm.
Good morning, Judge Paul Slough on behalf of Kent Family Farm.
Jeff Shimovitz on behalf of Benjamin Vaughn.
Good morning, Drew Norton on behalf of Curatolo Trust and Michael Yanis.
Good morning, Melissa Pranzalis on behalf of Mertz.
All right, thank you. We're on the record today for purposes of a hearing. Mr. Norton, on behalf of his clients, has filed a motion for summary disposition as to Mr. Vaughn's cross-claim against them, his clients. Mr. Norton, I did have a chance to review your motion and brief in support, as well as your reply to Mr. Shimovitz's response. Mr. Shimovitz, I did get your response. I had a chance to review that as well. Mr. Slough, did you file any written pleadings on this motion?
No, I did not, Judge. We don't take a position on it.
Okay,
Thank
and
you.
Ms. Pranzalos, did you file anything on this?
No, Judge. Same. We do not take a position.
Okay. All right, Mr. Norton, then, was there anything that you wanted to state in support of your motion today?
Very little, Judge. As always, we very much appreciate your preparedness. I know you've read the pleadings, as you just said. I know you know the facts. This is the third summary disposition motion, so I'm not going to belabor any of that. The highlights are, Judge, not only do I think it's insufficiently pled, but I think you basically decided our case too when you decided that Mr. Vaughn had constructive notice of the split and sale and reformed the parties' underlying documents relating back in time. In my view is that Mr. Vaughn wants to relitigate the notice issue. I believe it's been decided. I believe you decided it. There's no appeal pending that I'm aware of, or even a motion for reconsideration that I saw. To the extent that this articulated a fraud or concealment type claim, they fall woefully short. He falls woefully short of the particularity required by MCR 2.112B, let alone any evidence or even a prima facie case of any kind of intentional misrepresentation or anything like that. I didn't see the words innocent misrepresentation anywhere. Notice, in my view, then, Judge, has been settled. It's not in dispute. Discovery, I think, is closed. That was a little dicey, and you just said it once, and we kind of just plowed on. I didn't see a definitive time after, which went back a year, but we took steps. But in any event, regardless of what the record may show as a closing of discovery, we've done extensive discovery, in this case, written depositions as well, in support of the various motions that have been filed and the journey that this case has become. So it would be, we respectfully request that the court, whether it finds that there isn't an issue of genuine issue of material fact under C10 remaining as to the notice, and especially also or including any kind of fraud or concealment type claim under C10, we don't think there's a genuine issue. But also we think on the pleadings under C8 that you are well within your purview, Judge, to grant a summary disposition under 216C8 as well. Thank you for hearing me, Judge.
Mr. Norton, I have a question, because this is one factual, I think, issue that I don't remember having seen, and maybe it has been in one of the motions or recitations of fact somewhere. But your clients sold I'm just trying to figure out how to phrase this so it's as clear as possible. Your clients have essentially sold this 2.2 acre parcel twice. I mean, is that correct? Like once they sold to Kent Family Farms, and the second time it was sold to Mr. Vaughn as part of the larger 0.8 acre parcel. So my question, and this might be more for Ms. Prinzalis or Mr. Shimovitz, but it seems to me that somebody has overpaid here. And if we set aside the legal arguments, I mean, I'm just looking at this from a factual standpoint. I mean, have they received double for this extra 2.2 acres? Either directly in cash from Mr. Shimovitz's client or as part of the mortgage from Ms. Prinzalis' client?
So it's probably appropriate for at least Mr. Shimovitz, but I will respond because it certainly looks like on paper, certainly, and there lies. There's no question there was a mistake, more than one mistake in this case made, and on paper it looked like 8.8 acres was sold to Mr. Vaughn. What he paid for and what he believed he was paying for, I guess, is in his mind. And on its face, it may be that there was something extra paid for, or paid for twice, as you said. We showed up at mediation, and no one ever even put us on the screen. No one has come to us for money. It asked us what they think it's worth. That 2 point whatever acres is not a lot of money in the grand scheme of things to most people, except for Kent Family Farm. They had a strategic purpose for it, but a couple of acres in the middle of the forest up there or wherever. It's a fairly low number, but now we're 2 years in and tens of thousands of dollars of legal fees in. So, and we are looking at preparing for a trial. So I know that was a lot more than you probably asked for, but it is a question for Mr. Shimovitz and his client, what they paid for, what they thought they were getting. I mean, obviously they're going to say they thought they were getting the full 8.8 because that's what the papers said. You have held that he should have known and is put on notice that he was not getting 8.8 acres, and he knew that before he closed the deal and cut the check. So did he overpay? I don't think so. Thank you.
Okay, all right. Mr. Shimovitz?
Yes, sir. I think we have to start with this and the factual question of the constructive notice. So, Kent Family Farms had filed a universal, unlimited jury demand with their complaint. With that jury demand, every other party in this suit had the benefit of the court rule in question, which expressly says you can't withdraw a jury demand unless you have the consent of all of the other parties. Mr. Vaughn never consented orally or more specifically in writing to that withdrawal. Therefore, on anything that's a fact, it's for a jury to decide. But coming along directly to Mr. Norton's argument, my client not only had the expectation that it was getting the full acreage, he had the benefit of the seller's written warranty in their warranty deed that what he was getting was 8.82 acres, the entire parcel. Now, that really rings a bell. And the bell is when I'm going to shortcut them, refer to them as the sellers. When the sellers sold the 2.8 portion to Kent Family Farms in the preceding year, that was a split. It was two different owners. Sellers and the buyers were not the same. they were required to get a split approval. They never did until after Ben Vaughn paid the full amount for the full 8.82 acres in 2023. Going back to this question of mistake, we didn't make a mistake. We had no knowledge, constructive or actual, that the sellers didn't have the entire acreage. The only reason we didn't have the knowledge was they never filed a split approval application. They never filed a warranty deed from them to Kent Family Farms until after Ben bought his land, bought the entire parcel. Ben wasn't obligated to file a split because he was buying the entire parcel, as opposed to Kent, who had to file a split approval request because it was buying less than the seller's entire parcel. But again, I can't stress it enough. This is for a jury to decide. In Ben's deposition, as well as in his pleadings and in his affidavit, his sworn affidavit, he declared under oath that he not only didn't know, he couldn't see the fence. It was never up until today clear whether the photograph of the fence and the description of it centered or it was the subject of, was this visible from Ben's property? I could go along a lot longer, but I think I'll stop there.
All right, okay, thank you. And Mr. Norton, I'll give you an opportunity to respond, but I want to address Ms. Prinzales real quick before I move on back to you. So Ms. Prinzales, just kind of back to my question to Mr. Norton. I mean, your client gave a mortgage on the full property, right? And I'm assuming that they agreed to loan whatever money they loaned based on that property description.
That's correct.
So, I mean, what's your client? I mean, are they going to now want some money back because of the change?
So where we're at with that, Your Honor, after you had major rulings and the orders were entered with regard to plaintiff's motion for summary disposition, I had been in contact with all counsels and also my client because they do want to do an appraisal of the property. Obviously, we want to comply with the court's order and be able to do a partial release of our mortgage. But in order to do that, my client needs a new appraisal of the property, which Mr. Vaughn, as a party to the mortgage, is responsible to pay for. And then once my client does that appraisal, they will then decide at that point whether or not Mr. Vaughn will owe any additional funds, essentially tacking those on to the mortgage amount, or whether he won't owe anything. And we don't know that until there's an actual appraisal done of that portion of the property that is being requested to be released from the mortgage. And unfortunately, to this point, we haven't had any cooperation from Mr. Vaughn with regard to payment for that appraisal. Rather than tacking that amount onto the mortgage, it is required to be paid directly to my client prior to the appraisal being scheduled. So we're kind of in limbo with regard to that. I was hoping some sort of decision today may push that in a better direction as it relates to getting to that point. But my client is at a standstill as it relates to that partial release until they can appraise the property, which ultimately is not their financial responsibility.
Okay, and all right. on a kind of a different angle from this, though. I mean, your client paid Mr. Norton's clients X amount of dollars for the property. I mean, right now, your client hasn't pled any type of claim. You're just named in this as a party. But do you foresee a circumstance where you're going to be asking to amend this or add some type of claim against Mr. Norton's clients to recover some of the money that was paid to them? Or would you be going strictly after Mr. Vaughn for this?
Yeah, our contractual agreements with the mortgage and the note are with Mr. Vaughn. They're not with Mr. Norton's clients at all. So the agreement with regard to the mortgage and the funds with regard to the mortgage went to Mr. Vaughn, not to Mr. Norton's clients. So that's our position at this time. We have been standing by as being named as a party for notice purposes because we hold this mortgage, and hoping that these parties were able to figure something out and possibly resolve. Obviously, with the court's order being entered, that surely has put us in a better direction in terms of what we need to do. But we do need Mr. Vaughn's cooperation to do it.
Okay, understood. Thank you. Mr. Norton.
Thank you, Judge. Real quickly, the very purpose, so on this jury demand argument, the very purpose of C10 says that, is to dispense with trials if there is no genuine issue as to a material fact. You never get to a jury, so you can't bootstrap that. I mean, making the argument that it's preserved for a jury. Well, the purpose of C10 is, Your Honor, as you well know, is to dispense with that when there is nothing for a jury to decide. And that's what our argument here today is on that. I just heard Mr. Chimovich say his client didn't have knowledge, constructive or otherwise, of the fence line or the property line or the split. But that's patently false. You've decided they in fact did after a similar motion. So again, we respectfully ask the judge that you grant our motion for summary disposition. Thank you.
Okay. All right. Again, I've had a chance to review the briefs of the parties. I've had a chance to hear the arguments of counsel here on the record today. The motion was made pursuant to 2.116 C8 and C10. Mr. Norton correctly laid out the court standard of review for motions under those two court rules. And so the court adopts that as stated in the brief as the standard to be applied. The first operative fact, I think, here is the court's prior ruling as alluded to by Mr. Norton. And on a prior motion, the court found that Mr. Vaughn did have constructive notice. And so in my view, that's an issue that's been decided in the case. It's been decided that there is no factual dispute about that. So I do agree with Mr. Norton's argument that as it relates to his clients, he should be able to rely on prior rulings of the court. So in my view, that eliminates Mr. Schmitt's arguments regarding questions of fact on that issue and the need for a jury determination on that. The court has determined that as a matter of law, there's no genuine issue of fact on that would need to be decided by a jury. So I find that is a decided issue of fact in this case regarding constructive notice of Mr. Vaughn. And as Mr. Norton has argued that it applies to his client, I think it would provide a basis to the claims as pled by Mr. Vaughn, which involve, and I looked at the complaint, which involve claims of fraud, concealment, an improper personal protection order, inability to use the disputed property and attorney fees. That's all what's claimed in Mr. Vaughn's cross claim against Mr. Norton's clients. And if it is a decided question of fact that Mr. Vaughn had constructive notice, then none of those claims can possibly survive. And there is no question of fact under C10. And I find that Mr. Norton is also entitled to summary disposition of those claims under C8 as well, because as a legal matter, given the court's prior ruling, those claims simply cannot survive based on the pleadings alone. So while I do think there's a C10 component to this, I think Mr. Norton's primarily entitled to motion for summary disposition under C8 as to claims of fraud, concealment, and so forth as pled. And that leads to the other issue, which I kind of addressed here today in my questions to counsel about what do we do about the fact that Ms. Prinzalo's client has paid money by way of a mortgage for a certain amount of property, which they did an appraisal on and granted a mortgage based on that amount of property. And who's ultimately, going to be responsible for whatever her client wants back in the difference between what they gave a mortgage for and what that property is actually worth. And I think there may be claims out there, even in light of the fact that Mr. Norton's clients, I don't think, engaged in any fraud, concealment, or anything like that here. There was clearly mistakes made, as he indicated. And when I look at the court rules governing granting motions for C8 against the plaintiff, as Mr. Shimovit's client is here with regard to the cross claim, the court has to allow that party to amend unless that amendment would be futile under 2.116 I-5. So while I find that as a matter of law, Mr. Norton's clients are entitled to summary disposition to the claims currently pled, I also think because of this discrepancy in what was paid for the property and what Mr. Vaughn received, I think could lead to claims, and I understand Ms. Prinzalos, her point is their contract and their contractual relationship is with Mr. Vaughn, but I could foresee, an unjust enrichment claim perhaps on the part of her client on an implied contract. Maybe, I don't know. I was just thinking about this as I was getting ready for this. And certainly Mr. Vaughn's clients may have claims unrelated to fraud or concealment or something like that. But I think clearly there was money paid for the same piece of property twice in this case. And that to me means that there are potential claims out there and would not make amendment futile under 2.116 I-5. So the court is granting Mr. Norton's motion for summary disposition under 2.116 C8 as to the claims is currently pled. However, the court is going to allow 14 days for Mr. Shimovitz and or Ms. Prinzalos to amend or add claims under 2.116 I-5. If no amendments are filed within that 14 days from the date of today, then the court will consider any claims against Mr. Norton's clients by Mr. Vaughn to have been waived, and that would close that part of the case. Do you have any questions about the form of the ruling, Mr. Norton?
So, Judge, you certainly I heard you granted under C8. Are you also granting it under C10, just on some sort of limited basis? I certainly as to constructive notice, it sounds like, but.
Right. I'm sorry. I may have neglected to say that. Yes, C8 and C10.
Okay. Nothing further from me, Judge.
All right. So, Mr. Norton, I'll just ask that you prepare an order reflecting that ruling and submit that under the 7-day rule. And,
very good.
That's all we have.
Judge, I have a question on the ruling, if I may.
Sure.
Just to be clear that the amendment period you're allowing is against Mr. Norton's clients, not against Kent Family Farm.
That's correct.
Oh, okay. Yes, very good. As to us only. Judge, if I may?
Yes.
It sounded like you were signing off. This was a status conference originally. as well as, and then, my motion glommed on. I don't know if you want to do some housekeeping or not.
I did, I just noticed that, I was looking at the docket, where I was gonna disconnect, and I see that we do have it set for a status conference as well. I mean, I guess my suggestion would be to set this for a status conference in 30 days to see whether any amendments are filed, and then address how to go forward based on that. Do you have any objection to that, Mr. Martin?
Not here, no.
Mr. Slough?
I have no objection to that, Judge. I know that Ms. Prinzalos raised an important point, though, and that was this issue about Mr. Vaughn obtaining an appraisal. And I just wonder if maybe we shouldn't talk about that, before there's a show cause motion filed or something along those lines. We might be able to get that resolved now.
I mean, I certainly think that's something council needs to talk about. I don't know that I could make any kind of ruling or issue any type of order on that today without a motion and a hearing directly addressing that.
Yeah, I think that was going to be my next comment, is that I don't know that I would necessarily have an amendment to file, but maybe a motion to force the issue of payment of this appraisal in order to move this along. I think my client is going to maintain the position that because of the contractual relationship with Mr. Vaughn, that is who we expect the payment to be from. Obviously, he has filed his claims against Mr. Norton's clients, I think for that very reason, in terms of attempting to get some sort of resolution with regard to a breach of warranty, with regard to the warranty deed. So I think filings from my client's perspective may be a motion just to enforce that payment be made for this appraisal so we can move this forward. Otherwise, we're halted at this point in terms of compliance with the order that you've already entered.
Yeah, so Mr. Slough, to answer your question, I think Ms. Prinzalos is right in terms of procedure. I think that would have to be something that was filed as a motion and notice for hearing, and then the court would issue an order arising out of that.
Yeah,
As much as I'd
I'm not
like
looking
to get it taken care of today.
Yeah, and I'm not looking for the court to make a ruling today. I just thought since all counsel are here and it's a status conference, we could talk about the issue rather than have to go down the road of a show cause or a motion, but.
Yeah,
that's fine.
I'm open to that too. I mean, if the judge wants to disconnect and he's fine with us
Yeah.
speaking, I'm open to that.
Yeah, I can do that. This is my last hearing this morning, so I'm perfectly willing to go off the record, and you guys, no one else would have access to what you're talking about. So I'm perfectly willing to leave everybody connected if you'd like to do that.
Okay.
Speaking for Mr. Vaughn, I'm glad to speak with Ms. counsel for the mortgage company, but I'd rather do it in private between her and I. Not in the presence of Mr. Norton or Mr. Slough.
Okay, and that's fair. I'll let you guys decide how you want to do that going forward today.
One question I want to ask.
Sure.
Does the 14-day window start when this order is entered?
No, it's going to start from today's date.
Okay.
Okay.
Thank you, Judge.
All right. Okay, thank you. That's all for this hearing. And I think what I'm going to do is put you all into a breakout room, and then you guys can decide who wants to stay in and stay out for whatever conversations you're going to have. So let me put you all into a breakout.
Thank you, Judge.
Thank you.
Hi, whoever's joining us on the phone with the last 4 digits of 2246, can you tell me your name, please?
Yes, it's Ronnie Skorupski.
All right, thank you. We're going to get started with your case in just a minute, okay? I'm going to put you back on hold.
Okay, thank you.
Thank you. All right, sir, are you the same person that's called on the phone? Sir, on the Samsung device, can you hear me? Are you the same person that called on the phone? I can't hear you. Just nod your head if you're the same person that's on the phone right now. All I need to know is if you're on the phone right now at the same time. It's gotta be. It's Jackson County.
Yeah.
Okay. All right, Mr. Skorupski, are you there?
Yes, I am here.
Okay, great, thank you. All right.
Sorry about that.
That's okay. So we'll go on the record. This is People versus Ronnie Skorupski. This is Otsego County file number 941924-FH. The record should reflect that Mr. Skorupski is present by phone. Mr. Skorupski, my name is Judge Mertz. I'm presiding over this petition that you filed to have a conviction set aside from 1994. And so I've reviewed your petition, and there's a couple of issues here that we need to go through because you're going to need to submit some additional documentation.
Okay.
So what we don't have is you need to send this to the Michigan Attorney General's office, and they have to send me a report. You also have to either get fingerprinted or send some fingerprints to the Michigan State Police, and they have to submit a criminal history report to the court. And then the prosecutor also has to get notice of the hearing, which the prosecutor did not get notice of today's hearing. So there's a number of deficiencies here that are gonna need to be corrected before I could grant the relief you're asking for.
Okay. Well, I did send everything out to everybody, but I made a mistake and I didn't send it to the Michigan State Police with my fingerprints because I did all that. So I will resubmit everything out to them again this week. So the Michigan Attorney General office, I got to send that to the prosecuting office. And also, and I already did my fingerprints and all that, so I have that. So I just got to send that over to them. Are there only 2 places?
Those are the things that you need to do, yeah, because
Okay.
all I have here is, it looks like a register of actions from a court, maybe in Grand Rapids or something, but I need a report from the state police because that will indicate all of your criminal
Right.
history. So,
Okay, and then, so what do I do after I do that? I call back then and talk to somebody to set up another Zoom meeting?
yes, exactly.
Okay,
But
I will
make sure
do
you get
that.
make sure you get all of those things done, because otherwise we'll just have, excuse me, we'll just have to postpone it again and
Right. Nope, I totally
I don't
understand.
want to take up time on my docket and I don't want to waste your time either.
Right. Nope, I understand. I'll make sure that everything's where you need to be before I set the appointment for the Zoom call.
Okay, all right, very good. Thank you.
Yep. Thank you. Bye-bye.
Okay, bye. Mr. Warda, good afternoon. I don't see plaintiff's counsel present. Have you had any discussions with her recently?
I have not. It's a him, and I have not spoken with him.
Sorry.
No, yeah, not Robin Hultz, Kim.
Okay. Well, I'll give him a few more minutes to connect. And then we'll decide how we want to go forward. I have this set for a status conference today. Is that what you have as well?
It is. I'm happy to give him a call too if you'd like me to mute myself or anything like that.
Sure. Yeah, that would be great. Thank you.
Okay. Yep.
Okay, any word, Mr. Warda?
Yeah, I was able to get a hold of his secretary, and she is going in there right now. I passed along the Zoom ID, so hopefully we'll see him shortly.
Okay, sounds good. Thank you.
Yep.
Okay, we got everybody connected now, so we'll go on the record in Presqu'île Land Management versus GMC North Builders. This is file number 2620306, and if I could have both counsel put your appearances on. Mr. Corbin, you're muted.
Yes, good afternoon, Your Honor. Kim Corbin on behalf of the plaintiff.
And Brad Word on behalf of the defendant.
All right, thank you. We're on the record today for status conference. Last time that we met was back in April. Mr. Corbin, on behalf of plaintiff, can you tell me where things are at here today?
Yes, Judge, we are scheduled for a facilitation for next Tuesday with attorney Matthew Coffey. It had been scheduled for the following week, but he moved it up to the 14th.
Okay. I'm just wondering, I was looking through the pretrial order. Normally, I wouldn't have set this for a status conference until the close of discovery, which makes me think, did we talk about something that we would have set it for this 90-day period as opposed to further out?
Judge, you're asking the wrong guy because I took this off my calendar, I think mistakenly, because of the letter moving the facilitation. And I think both of you are just lucky that I'm not sitting here in my underwear because we don't have any air conditioning because of the storm over the weekend. So I have no problem with rescheduling this. I think I'm as stumped as you as to why it would be scheduled because, like I said, we've moved right along and we've got it scheduled with Mr. Coffey next week.
Okay. Well, I know my assistant said it because I put it in the pretrial order. So if it's anybody's fault, it's mine. But Mr. Werda, I mean, do we have any objection to just resetting this following this mediation?
No objection at all. I think maybe there was a question about trying to figure out a mediator with Mr. Corbin being downstate. So I think maybe that was the reason that you had scheduled it sooner than you typically do.
Okay. All right. So we'll set this out then. I'm going to set it for what is the close of discovery, which is in a couple more months. So
October 6th, I think.
Yeah, October 6th. So I'll set it for that date in October. My motion date in October, early October. And we'll see where we're at that point. Mr. Corbin, anything else I can address for your side today?
No, I'm good. Thanks, Brad, for calling me because I had scratched this off my calendar thinking that it was the rescheduled facilitation date.
Okay,
you're welcome.
Mr.
Yeah, nothing further from the defense as well, Your Honor.
All right, thank you, counsel. You're both free to disconnect.
Thank you.
Okay, Mr. Glazer, can you unmute and tell me what case you're appearing on today?
Good morning, Your Honor. I'm here on 0171CK MDC Contracting v. Mason Brothers Concrete. I'm here for the plaintiff.
Okay, gotcha. Thank you. Right. And I've got somebody connected on a Samsung device. Can you tell me who you are, please? All right, not sure who that is. Mr. Glazer, in your file, were you anticipating Mr. Ingleson appearing today? You been in touch with him?
There's been not very much communication. I mean, both parties attended mediation on this one in late May, and we haven't heard anything since. I don't have anything to indicate he wouldn't be here, but I also don't have anything to indicate he would. So a tough one for me to answer.
Right. Well, I mean, I guess I would. I'd indicate this. I'm looking at a status conference note of mine from May where Mr. Ingleson also didn't appear. So I guess what I'm going to do is set this for a show cause, Mr. Glazer.
Okay.
And then I don't know how, you know, on behalf of plaintiff, I mean, you're continuing to appear without defendant or defense counsel appearing. So I suppose I would leave that to you, whether you want to argue for some type of default or something. But
yeah,
I mean, I may consider it if Mr. Ingleson doesn't appear at the next hearing. This is kind of ridiculous that we have a counsel that's not appearing twice in a row. So I don't know if there's any record you want to make today, but that would be my intention, is to set this for a show cause for defense counsel's failure to appear for a hearing today.
Just to get it on the record, I would like to briefly make an argument for default today, if the court would allow.
Sure.
Thank you, Your Honor. With plaintiff at this time, based on defense counsel's failure to appear back in May and failure to appear here today, we would respectfully request default on plaintiff's claim and a dismissal without prejudice for the counter complaint filed in this case. There's been not very much prosecution based on the failure to appear. So we would request both of those things here today.
Okay. I'm not going to rule on that, I guess, Mr. Glazer. What I would say is, if you want to request a default, I would just ask that you put that in the form of a motion and notice it for hearing on the date that the court will set for the show cause. And the court would consider that, as well as, you know, any requests for fees for your appearances when Mr. Ingleson has failed to appear, assuming that he doesn't have some kind of proper cause for his failures to appear. So I think I need to hear all of that at the same time before I can make rulings.
No problem.
Okay. And if you need that date for your notice of hearing for your motion, just contact my office. Jennifer at my office can give you a date for that, and I'll just ask her to set that at the same time as the show cause.
Very well. Thank you, Your Honor. I appreciate your time today.
Okay. Anything else that you wanted to address today?
Not at this time. Thank you.
Okay. Thank you. That's all for this hearing, and you're free to disconnect.
Have a great rest of your day. Thank you, Your Honor.
Oh, that's all right.
Get out there. All right, good afternoon, council. We're on the record in Alexander versus Muma Logging. This is file number 2620453. If I could have council put your appearances on, starting with plaintiff, please.
Thank you. Good afternoon, Your Honor. Devin Bone appearing on behalf of the plaintiff, Maureen Alexander.
Good afternoon, Your Honor. Greg Light appearing on behalf of defendant Mark Olson Trust.
Okay, we're on the record today for purposes of a hearing. This court, through Judge Hesseling, signed a temporary restraining order back in May, at the end of May, regarding some logging operations that were allegedly taking place. This was set for a show cause today for a hearing as to whether or not that TRO should become a preliminary injunction and remain in place during the pendency of the case. I have reviewed the original complaint and motion for the TRO. I understand that that's been modified somewhat and that we've had a couple parties dismissed out of the case. So I know there's been a couple developments, but essentially the main part of the order, I believe, remains in place. And Mr. Light, I did receive your response. I had a chance to review that along with the supporting documents. And so I guess what I'd like to do is start with some arguments of counsel. And first, Mr. Bone, I guess I want to address you just based on what I read in Mr. Light's complaint. And I looked at the Otsego County, portal to kind of get an idea of where these properties are located and what the boundaries are and what the Otsego County records at least state with regard to who owns it.
Sure.
And I mean, it does appear to me that your client doesn't own the 72 point whatever acres. So can you explain why those allegations were made and those factual statements were made?
Yeah, right. I can give you a little bit of background. And maybe first, if it's okay, just kind of give you a setup of where we're at least procedurally, because there's been some other things that have been filed that I've received back that I don't know if they've made them to your bench yet, Your Honor. But we did dismiss out the two individual defendants, Mr. Beck and Mr. Martell, so they're no longer involved. It's just the Olson Family Trust and the logging company. I filed a first amended complaint after the TRO was entered. And there were surveys by Mr. Light's clients and my clients went out, and we kind of agreed that the 72 acre, the 80, I thought it was closer to 80, but the larger acreage of parcel was not owned by the Alexanders. We kind of agreed to that. That is that's kind of result, I think, universally viewed. The issue is just the logging activities on the 3.2 acre parcel. I think it's 3.2 that's owned by my client. The reason that we had included, and this was all kind of very quickly, filed, as TROs typically are, but when we initially viewed the Otsego County records, that record indicated that Maureen Alexander owned the 72 acre parcel. And there was always some belief, though it wasn't entirely clear what, other than on the deed, the tax ID that I filed as part of the complaint shows that tax ID was included in the deed. We'd sent a demand letter, or prior counsel before I was involved sent a demand letter trying to stop the activities once we discovered that. And then, we filed the TRO. And at this point, Your Honor, that part of it, I think, has been kind of resolved and established. The Olson Family Trust owns that larger parcel, and now it's a matter of the logging activities that occurred on the smaller parcel.
Okay.
So the odd thing from our perspective, Your Honor, after we filed this, the county records at some point were changed. I don't know how they were changed. Greg, I can't remember if you told me that they recently had been changed or if it was my client looking, but at some point it went from my client's name to, actually, I'm not sure if it's Mark Olson or who currently it's titled to, but that apparently that error was rectified. We worked with a title company to try and establish that the records we were looking at and that tax ID was accurate. They came back and said, yeah, it looks like, the Alexanders own that larger parcel. but that was kind of the genesis for the initial, the allegations, the initial complaint. I filed a first amended complaint narrowing that down since then. That's where everything stands now, Your Honor.
Okay, I have not seen that amended complaint, so that does clear up some of the questions I had.
It's interesting, Your Honor, because it just came back in the mail, but it was a first amendment complaint with a jury demand fee, and the check came back too, but I have a filed stamp on it. So I was going to call the clerk after this hearing and figure out if I need to resend it or what's going on. But there is a first amendment complaint that narrows it just to the 3.2 acres issue.
All right, so do we still need a preliminary injunction? I mean, if everybody agrees that that's Miss Alexander's property is the 3.92 acres and her property on that looks like a little peninsula on Aspen Road. If everybody agrees that that's her property, I'm assuming, Mr. Light, you're not arguing that your clients have the ability to log that property.
Absolutely not, Your Honor. It does appear that there was an error by the loggers in where they located that boundary line, but there was never any intention of logging her property. The trees that got taken, it's my understanding, were limited to it's 12 or 13 trees right along that borderline that have a stumpage value of less than $300. We have no intention of logging plaintiff's property, never did. I think we agree on the boundary line, so I see no need for any kind of continued injunctive order at this point.
I would add, with Mr. Light agreeing to that on the record, I agree. I don't think it's necessary at this point. I think the parties have kind of established where the boundaries are, and I take Mr. Light at his word. So I think we're pretty much fully resolved there, Your Honor.
All right, so Mr. Bone, I'll just ask that you submit an order dissolving the TRO, and either with a stipulation as to form for Mr. Light or under the 7-day rule.
Absolutely, Your Honor. We'll do.
But I'll know for the record here today that from my standpoint, the court is not going to limit, to the extent the TRO prevents the Olsons from conducting logging operations on their own property. The court is dissolving that effective immediately, regardless of when the order is signed. So, Mr. Light, your clients are free to do what they want to do, of course, on their own property.
I appreciate that, Your Honor. Thank you.
Your Honor, for what it's worth, I think actually under the TRO court rule that it may have already dissolved in its entirety, but I'll submit an order to dissolving it so that we have it properly papered.
Okay. And then in terms of how we want to go forward, Mr. Bone, I mean, do you guys want to have some time to talk about how to resolve this issue of it sounds like we would just be left with whatever the value is of the trees that were wrongfully cut.
Yeah, and I think the value of the trees, the damage to the property, I know Mr. Light and I have gone back and forth on some figures. It's not, my clients aren't seeking $100 million, but they're seeking more than $300. And I think if we had a little bit of time to maybe hash it out, see if there's something to be done, it might be helpful. If not, then, maybe we set this for a status conference in a month. And if it's not resolved, we get some discovery or, get a scheduling order in place, however the court prefers to handle that. And of course, whatever Mr. Light, wants to do as well.
If I may, Your Honor, I mean, I don't want to lose sight of the fact that we do intend to assert counterclaims based on the wrongful injunction that was entered. Here, there were damages to my client in terms of the value of the timber that got left out that couldn't be processed. So there are claims here that extend beyond just the value of the stumpage value of those 12 or 13 trees. I'm certainly open to trying to resolve this. We have had some discussion up to this point about trying to globally resolve this, but I don't want to let this languish too long. So, if we have 30 days to talk about it, and we can get our counterclaims filed if the amended complaint's been filed. But then maybe set this for a status conference and we can take it from there.
All right, I guess here's what I'd like to suggest then, and I'm open to if either of you disagree with it or object to it, is giving both sides and I know you've got your amendment going already, Mr. Bone, but giving both sides 30 days to amend or file any additional claims. And then set a 90-day cutoff for mediation. That would give, it doesn't sound like there's a whole lot of discovery that would need to be done. I would leave it up to you guys whether you want to do a community mediation or whether you want to spend the money on a facilitated mediator. This sounds like the kind of thing that maybe a community mediation might be effective on, maybe. And then just have discovery remain open during that 90 days, set this for a status conference at that point. If the parties haven't resolved it, then we can set up some more cutoff dates for dispositive motions and so forth. But that would give you each a chance to file claims if you want, some time to negotiate it before you take the step of actually filing any counterclaims and mediate. Mr. Bone, do you have any objection to that as a framework?
No, Your Honor, I think that's a fine framework. Thank you.
Mr. Light?
I agree, Your Honor. Thank you.
Okay, so I'll put those things into a status conference order that'll go out to both of you along with the date and time of that next status conference. And obviously, if you're able to resolve it before that, just notify the court and we'll take that down so that no one has to appear for that. Otherwise, that'll be our next meeting date. And then Mr. Bone, again, I'll just look for that follow-up order from you resolving the TRO so that we have that.
Sure, Your Honor.
As a second by the court.
For the next status conference, Your Honor, just for clarification, is Zoom okay for that as well? I know Mr. Light and I have a little bit of a drive if we're coming up.
Yep, I automatically schedule those by Zoom.
Cool.
So
right. Great,
yeah,
thank you.
No need for a special request on that. Okay, Mr. Light, anything further from your side?
No, thank you, Your Honor.
Okay, thank you. That's all for today. All parties in this file are free to disconnect.
Thank you, Your Honor.
Thank you, Your Honor.
I don't have a note for an amended. I said, I don't have any notes for an amended on that one.
Okay.
So.
Can you see those works?
Yes.
Mr. Crow, can you tell me what case you're calling in on, please?
Yes, Your Honor. I'm calling on the Leslie Hill versus Edward Hill matter.
Okay, very good. And Ms. Anderson, is that the case you're signed in on as well?
It is, Your Honor. Good afternoon. My client is here with me as well.
And my client is incarcerated, Your Honor.
Yes, and let's see, I do have him
And Your Honor, I did just want to note that I was retained on this case over the weekend. So I have not had a significant opportunity to review the pleadings of this case. But I know the conference was on today, so I certainly wanted to appear, but I just did want to let the court know that I've just been retained on this.
Okay. Certainly. All right. So let's go on the record then. This is Hill versus Hill, file number 2620420. We have Ms. Anderson here present, and on behalf of the plaintiff, we have Mr. Crow appearing today on behalf of defendant. Both parties are also present by Zoom here today. Ms. Anderson and Mr. Crow, this is typically a date where I would set just some preliminary dates for going forward. And Mr. Crow, obviously understanding that you're just getting involved in the case. Ms. Anderson, is there anything you want to request for scheduling on behalf of the plaintiff first?
Well, Your Honor, we will be filing a motion for the sale of the marital home. It's about to go into foreclosure again. So that needs to be handled, and I'll be calling your scheduling clerk for a date for that. I think we would agree to mediation if defendants are amenable to that. Other than that, I think that's all we feel we need.
So we would be amenable to mediation, and I certainly look forward to speaking and working with Ms. Anderson. I will be in contact with her after our appearance today or tomorrow to discuss the matter. And if Ms. Anderson declined on filing a motion, certainly look forward to reviewing and responding to the same.
Okay. Is there any reason why we couldn't use community mediation here? Is there anything particularly complicated regarding the marital estate?
No, Your Honor, the marital estate is essentially going to be the marital home. Personal property, I don't think is going to be of issue. And that's really the only asset in this case is the marital home.
Okay, so if we set a mediation deadline for 60 days, is that enough time for both of you, do you think?
Yes,
I
Judge.
feel that would be sufficient, yes.
Okay, so here's what we'll do. I'm just going to order that discovery to remain open to the extent that either of you needs to do that. Ms. Anderson, to the extent you have any of those types of motions, I'll ask that you just get that filed within the next 30 days. And then I'll put in the order that parties to participate in community mediation within the next 60 days. And then I would set this for a status conference at 60 days. If we've been able to reach agreement and all matters have been settled either by motion or by the negotiation of the parties, we could use that date to enter judgment and take proofs. And if not, then we can discuss further scheduling to get it resolved from there. Ms. Anderson, any objection to that time?
No, thank you. That sounds good.
No objection, Judge. Thank you.
Any other dates that either of you would like, or matters that either of you would like to address before we go off the record?
Not at this time, Judge.
None for plaintiff. Thank you, Your Honor.
All right, so I'll put the dates we've discussed today into a status conference order that'll go out to both of you. Also, the court will send out notice of the date and time of that status conference in about 60 days, and that'll be by Zoom as well, just as we're doing today. And thank you both. Everybody's free to disconnect at this time.
Thank you, Your Honor.
Are we through?
Yes, I'm sorry. We'll go ahead and just.
All right, thank you. All set?
ma'am, if you can unmute, please.
Okay.
There we go. Are you Amanda Delane Paul?
Yes.
Okay, we'll go on the record in People versus Paul, I'm sorry, Paul versus Paul. This is file number 26-20433. The record should reflect that the plaintiff Amanda Paul is present today by Zoom video. I do not see Mr. Paul in the Zoom waiting room.
Oh, geez. Okay.
Which is fine. This is a scheduling conference today. So Ms. Paul, what I try to determine at this kind of preliminary hearing is whether or not there are matters in dispute between the two of you. And so what kind of hearings I need to order to get those resolved, or whether you've essentially agreed on how to divide things up and we just need to get a date to finalize the divorce. So can you tell me from your standpoint at least?
Okay, so we've been separated for 3 years. We have no assets, no children, there's nothing.
Okay, so from your standpoint, there's nothing to divide up.
No.
Okay, and are you requesting any kind of alimony or spousal support?
No.
Okay.
Mm-mm.
So, all right, so what I can do then is set this for a final hearing date. And I will send out notice of the date and time of that hearing, just like we did for today's hearing. It'll be by Zoom, just the same way today's hearing is by Zoom. There's one final form that you're going to need to file before that next court date, though, and that is called a judgment of divorce. And you should have that form, or you'll be able to get that form the same way that you got your forms to file for the divorce in this case.
I already filed everything I was supposed to file, so.
Okay, well.
I just got an email that Jesse Paul's in the waiting room. He's not. Okay. All right.
So, Ms. Paul, you filed what you needed to file to start the divorce, but there's a final form called the judgment of divorce that you will need to, you'll need to fill that out and get that to the clerk's office before the next hearing date.
Okay.
And as long as you do that, then we'll be able to finalize things and have the divorce be over on that date. If you don't get that form, then we'll just have to reschedule it. So that's an important step for you to follow through with. Okay.
Okay. All right.
Do you have any questions?
So I'm gonna go to the clerk.
What's that?
I'm just gonna go to the clerk.
Well, you need to get the form and then submit that to the clerk's office.
Mm-hmm.
Yeah. Yes. Okay. Good. Okay. Do you have any other questions?
No, sir.
All right. So just look for that hearing date in the mail. Make sure you get that form in prior to that date. And that's all for today. Thank you. You're free to disconnect.
Thank you so much.